Hello बच्चों, let's see the passage 1. Passage 1 says regarding the rights of the indemnity holder, Section 125 of the Contract Act outlines the following entitlements. Section 125 of the Contract Act talks about the indemnity holder. What are the rights available to them? The right to recover damages. The indemnified has the right to recover all the damages imposed on them in a lawsuit pertaining to the matters covered by the contract. तो ये राइट ये बोल रही है कि अगर कोई भी द इंडेमनिफाइड हैज द राइट, जो भी इंडेमनिफाइड है उसके पास राइट टू रिकवर होती है जो भी डैमेजेस अगर उसको कोई लॉ सूट से हुए हैं वो अगर कॉन्ट्रैक्ट कवर करता है तो. And second right is right to recover costs. The indemnified is entitled to claim all the costs during the institution and defense of the lawsuit. Indemnified के पास दूसरी right होती है to recover the cost. वो सारी cost cover कर सकता है जो एक institution और defense of the lawsuit में use होता है. Right to recover sums paid under the compromise. The indemnified can recover any amount paid as per the terms of settlement agreement. However, it is essential to ensure that the compensation aligns with the indemnifier's direction, is reasonable and authorized on the indemnifier. On the other hand, the rights of the indemnifier are not explicitly outlined in Section 125. It can be inferred from the indemnifier bears liability rather than possessing specific rights under the contract. अब ये लाइन बोली कि जो indemnifier होती है उसकी राइट्स सेक्शन 125 में नहीं दी हुई है. उसकी राइट हम ये लाइन से निकाल सकते कि इट बियर्स लाइबिलिटी रेदर देन पोसेसिंग स्पेसिफिक राइट्स. उनके पास ये ऑब्लिगेशन होता है कि उनको लाइबिलिटी बेयर करनी है, कोई स्पेसिफिक राइट्स नहीं होती है. ठीक है. मूविंग ऑन द कॉन्सेप्ट ऑफ कॉन्ट्रैक्ट ऑफ गारंटी, इट इन्वॉल्व्स अ श्योरिटी, द पार्टी गिविंग द गारंटी. अब कॉन्ट्रैक्ट ऑफ गारंटी जब होता है तो उसमें सबसे इम्पोर्टेंट पार्टी होती है श्योरिटी. अब श्योरिटी कौन होती है? श्योरिटी वो पर्सन होता है जो गारंटी देता है, agreeing to perform a promise or discharge of the liability of a third person, the principal debtor in the case of their default. अब श्योरिटी क्या होता है? श्योरिटी प्रिंसिपल डेटर जो है उसको डिफॉल्ट के अगेंस्ट एक गारंटी देता है. द पार्टी टू हुम गारंटी इज प्रोवाइडेड इज नोन एज द क्रेडिटर. अब जो क्रेडिटर है उसको जो है श्योरिटी वो गारंटी देता है कि भाई जो डेटर है, मतलब जिसने पैसे लिए हैं या कोई प्रॉमिस किया है काम करने का, वो आपको करके दे देगा. अब ये गारंटी जो है वो ओरल भी हो सकती है या रिटर्न भी हो सकती है. To illustrate this, consider the following example. We request A to sell goods on credit and A agrees on the condition that C guarantees the payment of the price. C's promise to guarantee the payment serves as sufficient consideration for A's promise to deliver the goods. अब इसमें जो C है, C will be the surety in such case because उसने गारंटी दी है for the B. Okay, A sells goods to B and later C requests A to refrain from suing B for a year. In return, C promises to pay for the goods if B fails to make the payment. A agrees to this request. This arrangement also constitutes valid consideration for C's promise. अब इस केस में जो है C वो होगा श्योरिटी. अब bailment and pledge are two additional types of contracts worth mentioning. Bailment refers to the transfer of possession of goods from one party to another party for a specific purpose with the expectation of redelivery. This arrangement typically involves safekeeping or utilization of the goods by bailee. अब बेली कौन है? बेली वो पर्सन है जिसको गुड्स मिल रहे हैं एंड बेलर वो पर्सन है जो गुड्स को दे रहा है. On the other hand, a pledge involves the transfer of goods as security for a debt or obligation. अब इसमें pledge और bailment में difference क्या होता है? bailment utilization या safe keeping के लिए होता है. अब pledge जो है वो as a security होता है for any debt or obligation. The party providing the security is called pledger and the party receiving the security is called pledgee. If the pledger defaults on their obligation, the pledgee has the right to sell the pledged goods to recover the debt. In conclusion, contract of indemnity, guarantee, bailment, and pledge are distinct in their nature and purpose. Now let's see the question. Question number 1 says a contract with B A contract with B to indemnify B against any legal consequences arising from a business transaction with C. However, C brings a fake lawsuit against B, causing significant losses to B. In this situation, what rights does B has, the indemnified party possesses under the contract of indemnity? अब इसमें कॉन्ट्रैक्ट ऑफ इंडेमनिटी जो है वो ए और बी के बीच में हुआ था, जिसमें थर्ड पार्टी इन्वॉल्व जो थी वो सी थी, ओके, और बी और सी का कॉन्ट्रैक्ट हुआ था जिसके लिए ए ने इंडेमनिफाई किया था। अब इसमें फॉल्स लॉसूट कर दिया सी ने, तो अब बी के पास क्या राइट्स है एज अ इंडेमनिफाइड पार्टी, हमको ये बता। Let's see the options. Option number A says B has the right to recover damages, costs and sum paid under the compromise from A, the indemnifier. अब ऑप्शन नंबर ए बोल रहा है कि बी के पास सारी राइट्स हैं, वो डैमेजेस भी मांग सकता है, कॉस्ट भी मांग सकता है और सम पेड भी मांग सकता है फ्रॉम ए. दिस इज द राइट ऑप्शन बिकॉज ए हैज इंडेमनिफाइड बी with all transactions with C. तो अब अगर C एक फॉल्स लॉसूट ला देता है A के ऊपर, तो इसके भी सारे कॉन्सिक्वेंसेस A हैज टू ओनली बेयर. तो इसके जो भी लीगल कॉन्सिक्वेंसेस होंगे, for any legal consequences, A will have to bear all the damages, costs and sums. So this is the right option. This is the proper scope of the indemnity contract. Now let's see option number B. Option number B says B has no right as the indemnified party. Only A, the indemnifier, has the right under the contract. This is saying opposite of what the typical indemnifying contract says. So this is also a wrong option. Option number C says B has the right to recover damages and costs but not the sum paid under the compromise. B has right to recover damages, cost and also sum paid. And this says not sum paid, so this is also a wrong option. Let's see option number D. Option number D says B has the right to recover damages from A, the indemnifier, but not cost or sum paid under the compromise. B has the right to recover damages, that is true, but it also has the right to recover the cost and sum paid. So this is a wrong option because it says no right. Now let's see the question number 2. Question number 2 talks about A guarantees the repayment of a loan taken by B from a bank. However, B defaults on the loan and the bank demands repayment from A. A refuses to pay, stating that the guarantee was provided under coercion. In this situation, what is the likely outcome under the law of contracts? Let's see the options. Option number A says the guarantee provided by the A is voidable due to coercion and A is not liable to repay the loan. Here, the repayment of the loan is depending upon the contract of law. लॉ ऑफ कॉन्ट्रैक्ट्स के बेसिस पे हमको ये बताना है कि रीपेमेंट ऑफ द लोन के लिए ए की गारंटी यूज होगी या नहीं होगी. ऑप्शन नंबर ए से इसकी वॉइडेबल हो जाएगा कॉन्ट्रैक्ट. ऑब्वियसली द कॉन्ट्रैक्ट विल बी वॉइडेबल बिकॉज जो गारंटी दी गई थी by A was under the coercion, and according to law of contract, if there is consent given by coercion, the uh, the contract becomes voidable at the part of the party who was coerced to give the consent. So A is the right option. Let's see option number B. The guarantee provided by A is valid and is legally obligated to repay the loan. If A able to prove that his or her consent was due to coercion, then it is not the liability of A to prove to give the to repay the loan. So this is also a wrong option. Let's see option number C. The guarantee provided by A is void due to coercion and the bank cannot demand repayment from A. Here the question is whether the guarantee provided by A will be valid or not. So it is void due to coercion, whereas it is voidable, not void per se due to coercion, and bank cannot demand repayment. That is the further question which has not been asked. So this is also a wrong option. Let's see option number D. The guarantee provided by A is valid, but A can claim damages from B for defaulting on the loan. This is not related to the contract of guarantee, so this is also a wrong option. Let's see question number 3. A pledges his car to B as security for a loan. However, A fails to repay the loan within the agreed upon time frame. In this situation, what rights does B, the pledgee, have under the contract of pledge? अब इसमें क्या हुआ है कि A ने अपनी कार B को दे दी है as a pledged good in order to get some loan. अब A जो है वो रीपे करने में फेल हो गया है, तो अब B एज अ प्लेजी क्या कर सकता है, उसके पास क्या राइट है, वी नीड टू फाइंड दैट आउट. Let's see options. Option number A says B has the right to sell the pledged car and recover the loan amount from the proceeds. This we have read in the passage that if the pledger fails to repay the loan or perform the task, the pledgee has the right to sell the good and recover the loan amount. So this is the right option. Let's see option number B that says B has no rights as the pledge, only A, the pledger, has the right under the contract. This is a wrong option because B does has the right to sell in case of non-payment of the amount. B has the right to retain the possession of the pledged car until A repays the loan. This cannot be for unlimited time period. It is just for the limited time period that is decided under the contract. If until that time period the pledger is unable to pay the loan, the pledgee has full rights to sell the uh, good in possession. So this is also a wrong option. Let's see option number D. B has the right to demand additional collateral from A recovering the outstanding loan amount. This is also a wrong option. Let's see question number 4. Question number 4 says A and B entered into a contract where A agrees to indemnify B against any loss resulting from a business transaction. However, it is later discovered that the business transaction itself is illegal and against the public policy. In this situation, what is the legal status of the contract of indemnity? अब हमको राइट्स नहीं डिस्कस करनी है, हमें लीगल स्टेटस ऑफ द कॉन्ट्रैक्ट डिस्कस करना है. अभी ऑलरेडी पैसेज में मतलब क्वेश्चन में बोल दिया है कि the object was illegal and against public policy, and we know under contract law if any contract has its object that is illegal or against the policy, such contract is void. Now let's see the options. Option number A says the contract is valid and enforceable despite the illegal nature of the business transaction. This is per se looking कि ये illegal nature of the business transaction की बात कर रहा है और फिर validity की बात कर रहा है. These are two opposite things in the contract of law. Either it is valid or it is non-illegal. So this is also a wrong option. Let's see option number B. The contract of indemnity is void because the object of the agreement is opposed to the law and public policy. This talks about void nature of the contract, and the reason of the same is object is opposed to law and public policy. That is the correct answer. Let's see option number C. The contract of indemnity is voidable at the option of B due to the illegal nature of the transaction. जब इलीगल नेचर ऑफ द ट्रांजैक्शन आ जाता है तो यहाँ पे किसी पार्टी पे डिपेंड नहीं करती है वैलिडिटी ऑफ द कॉन्ट्रैक्ट. इट इज पर से वॉइड, मतलब ये वॉइड ही है. ये अगर कोई पार्टी हाँ भी बोल देती है तो ये ऐसा नहीं हो जाएगा कि इसका स्टेटस वॉइडेबल है इसलिए वैलिड हो जाएगा. सो दिस इज ऑल्सो रॉन्ग ऑप्शन. Let's see option number D. The contract of indemnity is valid but both the parties are equally liable for the losses incurred. इसमें लॉस की तो बात ही नहीं की गई है, इसमें तो नेचर ऑफ कॉन्ट्रैक्ट जो है वो इलीगल बोला गया है. सो दिस इज ऑल्सो रॉन्ग ऑप्शन. लेट्स सी क्वेश्चन नंबर 5. Question number 5 says A guarantees the repayment of a loan taken by B from a bank. However, the bank modifies the terms of the loan without the consent of A, resulting in the higher interest rate. B defaults on the loan and bank demands repayment from A based on the modified terms. In this situation, what is the likely outcome under the contract law of contracts? अब इसमें क्या है कि A जो है वो गारंटर है और B जो है उसने एक लोन लिया है बैंक से. बैंक टीएनसी चेंज कर देती है लोन का जिसकी वजह से इंटरेस्ट रेट बढ़ जाता है. अब ए को इस चीज की नॉलेज भी नहीं होती है और उसने कंसेंट भी नहीं दिया होता है. बी जो है वो डिफॉल्ट कर देता है पेमेंट ऑफ लोन में एंड नाउ अब इसका आउटकम क्या होगा, वेदर ए वुड बी लायबल टू पे द लोन अमाउंट और नॉट. We need to decide that on the basis of law of contract. Now let's see the options. Option number A says A is not liable to repay the loan due to the bank's modification of the loan terms without A consent. ये breach of contract जरूर है क्योंकि बैंक ने A का consent नहीं लिया था, but that doesn't mean कि A की सारी liability to repay the loan has gone away. So this is a wrong option. Let's see option number B. A is still obligated to repay the loan but only based on the original terms agreed upon between A, B and the bank. जो टर्म्स है वो जरूर चेंज हो सकती हैं, दैट डजंट मीन कि ए बी एंड बैंक की जो ओरिजिनल टर्म्स थी उसी पे ए को रीपेमेंट करना है. दिस कैन बी चेंज, सो दिस इज ऑल्सो रॉन्ग ऑप्शन. ऑप्शन नंबर सी सेज ए इज लाइबल टू रीपे द लोन बेस्ड ऑन द मॉडिफाइड टर्म्स एज लॉन्ग एज मॉडिफिकेशन इज विद इन द रीजनेबल रेंज. अब ये जो है वो रीजनेबल रेंज की बात करता है. अगर हम किसी कॉन्ट्रैक्ट ऑफ लॉ अगर हम कॉन्ट्रैक्ट ऑफ लॉ के बेसिस में कोई भी कॉन्ट्रैक्ट को देखें तो अगर किसी इंसान ने श्योरिटी दी है फॉर द अनदर पर्सन, द पर्सन इज स्टिल लाइबल फॉर द पेमेंट और रीपेमेंट ऑफ द सेम until and unless the reasonability of the contract is maintained. If that is beyond the reasonableness, then the person is not liable. But in the cases which fall within the reasonable range, the surety has to repay the loan, and this reasonability is decided on the basis of several factors. So this is a right option compared to all others. Let's see option number D. A is only liable to repay the loan based on the modified terms if A was made aware on the modification before the providing of the guarantee. अब भाई modification हुआ ही after providing the guarantee है तो उसको beforehand बताएंगे कैसे? So this is also a wrong option. So out of the all four, C is comparatively the most correct answer. So we'll mark C as the correct answer. I hope the passage was understood. Keep studying. All the best.